from trade list. This case item 11 WBC 5. Item 11, item 12 WBC 421 of 2016.
Where is washing of part order dated 16/9/2015 errors, wherein the written statement filed by the petitioners have been refused to be accepted by the blended tribunal. And Worship, for question of the part order, for the direction of the Worship filing written statement by the petitioner to be accepted.
Read the order. Read the order. When was the suit filed? What is the timeline?
The suit was filed on 16. The suit was instituted on 20th November 2013. And the same was admitted on 22nd January 2014.
When was the notice served?
Notice has been served on 24th March 2014. And then order for ex parte proceeding was passed on 4th June 2014. And thereafter, Your Lordships, petitioners were appeared as defendant in that case on 16/7/2014. And thereafter, for recall of that order and written statement, a petition was filed on 5th November 2014. This was the delay.
5/11/2014. So just a moment. Suit filed, right? Then 22/1 admitted. Then 24/3 notice served.
Yes, sir.
90 days expired when?
Yes, sir.
When did 90 days expire?
90 days expired on in the month of June, Your Lordships, expired.
Then 16/7/2014 the WS was filed.
No, Your Lordship.
16/7/20
they only appeared in this case.
And 5/11/2014 petition
And
seeking
petition recall petition was filed by Your Lordships. And WS was being filed, Your Lordship, but it was refused.
Now read this order.
Order on the petition dated 5/49, page number 14. Order 49. Order on the petition dated 5/11/2014, filed on behalf of the defendant, except the WS filed by him recalling the ex parte order dated 4/6/2014, and its rejoinder of the same date filed on behalf of the plaintiff. Law attendance has been filed on behalf of the plaintiff and the defendant. Today, the case is fixed for order on the above mentioned petition filed on behalf of the defendant and its rejoinder filed by the plaintiff. The learned counsel for the defendant and plaintiff have set forth their hearing in support of their respective petition and rejoined on the previous occasion. And this is how the case has come up for today. Heard both sides, the learned counsel for the petitioner placing his petition for the acceptance of WS filed by him, recalling the ex parte order dated 4/6/2014, submitted that the petitioner appeared in this case on 18/6/2014, but due to inadvertence, the petitioner defendant were not able to file petition to recall the ex parte hearing, and further submitted that the defendant number 1 is an old lady suffering from different ailments, and two other defendants are sons of the defendant number 1. Hence, they were busy serving their mother, that is defendant number 1, and thus there is delay taking proper step. It is further submitted the ends of justice, and the case be disposed of on its own merit. The ex parte order dated 4/6/2014 be recalled and the WS filed for the defendant be accepted. On the other hand, the learned counsel for the plaintiff pressing his rejoinder vehemently opposed the said petition for recalling the ex parte order dated 4/6/2014 and accepting the written statement stating that he, defendant, should have filed a petition for recalling the order of ex parte hearing on the very first day of appearance, and further submitted that the explanation given by the defendant for recalling order of ex parte hearing is not satisfactory, as there was personal service of notice on defendant number 1 on 24/3/2014, as fine mentioned in the service report of the process server of Nazaret, and the notice on defendant number 2 and 3. And similar notice of defendant number 2 was received by her mother, and further the notice for defendant number 3 was received by her wife on the same day. But despite that, defendant caused in their appearance, owing to which the suit was fixed for ex parte, as such prayed that the petition filed by the defendant should be rejected. When thoroughly through the entire case record, it is apparently clear that the suit was admitted by order dated 22/2014, and thereafter summons was issued for the issuance of the appearance of the defendant by process of court as well as by registered post on 7/3/14 and 10/3/14 respectively, and that the service report of the said notice issued on the defendant has been received, and which is on the record. And from perusal of the report of the process server, it is apparently clear that there is personal service on the defendant number 1, and the notice on defendant number 2 has been received by her mother, and notice on defendant number 3 has been received by her wife Ashalata Ghosh. And all the notices have been received on 24/3/2014, and thus it is apparent that the defendants have knowledge about the present case, but despite that they did not cause their appearance and appeared as on 16/7/2014 and prayed for time for filing WS, which was rejected as a suit proceeded ex parte, and ex parte order was not recalled, and that after appearance on 16/7/2014 the WS was filed on 5/11/2014 along with a prayer for setting aside the ex parte order. It appears that the defendants, despite having knowledge about pendency of the suit and summons have been received by them on 24/3/2014, did not appear in the suit deliberately and intentionally, owing to which the suit proceeded ex parte while order dated 4/6/2014, and despite their appearance on 16/7/2014, the WS has been filed on 5/11/2014 after a lapse of about 4 months without recalling the ex parte order, and as it is long deliberate and intentional default on the part of the defendant in causing their appearance and filing the WS after a period of more than 3 months after their appearance and more than 7 months from the receiving of the summons. The plea of ill health of the defendant number 1 appears to be a simple excuse as medical prescription is on 1/4/2014, much before the appearance in the suit. As such, I am not inclined to accept the WS filed by the defendants. However, the defendants have caused in their appearance, they will have the liberty to contest the suit without WS.
Please, what is the illegality in the order?
Without WS, if they will contest the
No, you had the opportunity to file your WS. Why didn't you file it?
Your Worship, so my mother was seriously ill. Now she is no more also, Your Worship.
You have given the medical certificate of the year of January 2014.
But Your Worship,
Your conduct from 24/3/2014 onwards. How do you explain it?
Worship, mother has received the notice on behalf of defendant number 1 and Your Worship, wife of defendant number 2 has received the notice, Your Worships. डेट्स के बीच में सिर्फ 2 डेट ही पास हुए थे लॉर्डशिप्स इसमें वो अपील करके नहीं फाइल कर पाए
Let me know. What is the time for filing written statement?
लॉर्डशिप 30 days after 90 days
बताइए the CPC खोल के निकालिए
लॉर्डशिप
30 days.
civil cases the defendant shall within 30 days from the date of service of summons lordships on him present a written statement of his defense
कहाँ पढ़े?
order each lordship to
पढ़ी पढ़िए.
The defendant shall within 30 days from the date of service of summons on him present a written statement of his defense, provided that when the defendant fails to file the written statement within said period of 30 days, he shall be allowed to file the same on other day as may specify to the court for reasons to be recorded in writing, but which shall not be later than 90 days from the date of service of the summons.
So initially 30 days and then yes, we are there for the respondent.
Yes.
Initially 30 days and then it may extend up to 90 days.
And after cost, it may extend up to 1 million.
Upon cost. It shall not be later than 90 days from the date of service. Right? क्या बोलना है आपको?
So my submission to the effect is that there is a delay of 4 months. Provision says that it is directly in nature, it is not mandatory.
So you see, you just say. The notices were served upon one wife,
Yes,
with respect to one person to the wife, with the second person to the respondent, to the mother, right?
yes, ma'am.
Is there any order accepting the notice as valid? Is there any such order accepting the notice as valid? Tell me.
The state 30th of April 2014, there's the office to call for service report of summons
Yes.
served through Najara notes and subsequent date on 4th of June 2014. If the order has been passed as a
No.
the
Just a moment. The notice was served upon the wife and notice was served upon the mother. Right? Is there any order that notice is sufficient, accepted as valid? Is there any such order?
Prior to that, there is only order of 30th of April.
You read 30th April order.
It's law of the plaintiff files against office to call for service report of summons issued through Najara and for of service report and appearance of the defendants on 4th of June 2014.
Then read 4/6 order.
Attendance on behalf of plaintiff is filed service report is on record. The usual of service report reveals that there is a proper service on the defendant on 29th of March 2014 but till date defendant, despite having knowledge, has not turned up, and the suit is fixed to proceed ex parte against the defendant, put up on 10th of 18th of June.
And this ex parte order has also been passed before the expiry of 90 days. Right? Nobody is appearing on their behalf, and as per the order, it has been served upon the wife and mother.
Because I'm only relying on because my submission to that effect was that my fair submission to that effect is that the provision itself is directly, it is not mandatory in nature. But Honorable Supreme Court in some of the cases has come to a particular finding that the parties must be aware and must be bona fide and must appear in the court so that the adjournments of the proceedings should not be provided by the presiding officer, the matter must be decided.
That's right, you see, that's right. Which judgment have you got?
That's the latest judgment. 2023 SEC Online SC 1377. Paragraph 31. Paragraph 51.
You see, this case is arising out of a proceeding which was much prior to the amendment. So, the law is very different thereafter. The law is not the same.
In our engineering, also Honorable Supreme Court has said that it is plain, it is not mandatory. Paragraph 14, 15. Paragraph 3 is singular. Paragraph 14, 15.
14 and 15. see, the period is 30 days, and by the order of the court for after citing reasons, it is extendable, right? So, if there are reasons shown that there has to be some extension, then it can be extended. The summons have been served on 24/3/2014, and then you have filed your petition for recall on 5/11/2014. You have appeared on 16/7/2014. So, what is the explanation for this period given in your petition?
We have annexed medical prescriptions, Your Worships.
That you have given one medical prescription there only.
As
New documents cannot be introduced here. Can it be introduced here? Your new documents cannot be seen over here.
In 2012, Your Worship, knee replacements
That is not those documents. Why didn't you file it before the court? We are under 227 jurisdiction. We cannot allow
knee
you.
documents cannot be introduced. PC 1271 of 2016, Lordships की cost लगा के 1600 days के Lordships delay for written statement
कहाँ? इसका क्या मतलब है आपका?
PC 1271
तो क्या करें हम इसका? आपका मोबाइल हम ले लें? क्या करें? आप तो ऑर्डर ही नहीं लेके आए, मोबाइल को लेके खड़े होंगे. We'll allow them to file the written statement.
One more judgment of coordinate bench CMP.
See, मदर को दे दिए, भाई को दे दिए, कोई ऐसा डीम्ड एक्सेप्टेंस का ऑर्डर नहीं.
But they have.
There has to be an order, no? That the notice is accepted as validly served since it has been served upon the closement. That order is not there. That order is not there. Isn't it? So that advantage they have, so far as that is concerned. Ex parte करने से क्या फायदा है? Stay है. Stay है.
Yes, stay was granted.
Stay है. कुछ नहीं पता है किसी को. Stay है इसमें.
Yes.
It is stayed. The proceeding is stayed. कौन सा ऑर्डर आप बोल रहे थे? Which order were you saying? WPC? WPC number?
1271 of 2016.
देखिए तो इसका ऑर्डर. बहुत दिन हो गए ये मैटर्स नहीं किए हैं, बहुत दिनों से. So I just wanted to know what is is a recent trend. 2016 कब हुआ डिसाइड?
ये 19 में डिसाइड 12
आप बताइए तो क्या कर रहे हैं आजकल रिटन स्टेटमेंट में जल्दी?
2005 4 SCC page 480
Yes,
2000
Your Worship, ये judgment.
Kailash versus
अब ये क्या है?
Neptune. Order 8 rule 1 is not a mandatory letter, it is a directory. The second bar advocate will say you has been taken by the Honorable Supreme Court 2005 6 SCC page 3448.
That is a judgment. Your Worship.
So depending upon the circumstances, it can be taken.
It is not mandatory. A sufficient reason is paramount consideration.
ये है.
Now it is for you to explain what was the reason for not filing the written statement. Yes, you have to give me some explanation, no? What is the explanation for not filing, not taking steps in the case
Just because Your
from
Worship,
the period of appearance till you took steps on 5/11/2014?
this was the reason given that petitioner one was undergone hip replacement treatment. Your Worship, thereafter उनको चलने फिरने में दिक्कत थी तो Your Worship सारा they were taking care of our Your Worships. That's why they are busy.
I heard the learned counsels appearing on behalf of the parties. This petition has been filed for the following relief. The learned counsel for the petitioner, while giving the timeline, has submitted that as per the records, the suit was filed on the suit seeking declaration of title.
Yes.
The suit seeking declaration of title
Page 25 is the prayer portion of
yes.
right for declaration of right title and interest
Hmm.
for confirmation
Yes.
of position of
That's right. Suit seeking declaration of right title and interest and for confirmation of possession was filed by the plaintiff as back as on 20/11/2013. It was admitted on 21/2014 and notices were issued. She submits that as per the improved order itself, the notice was personally served upon defendant number 1, but so far as defendant number 2 and defendant number 3 are concerned, the notice was received by their mother and wife respectively. The learned counsel submits that the petitioners were engaged in taking care of the defendant number 1 who was undergoing medical condition, and a prescription was also filed before the court which is dated 1/4/2014. The learned counsel submits that on such circumstances, the petitioners could not appear before the court and the proceeding was set ex parte on 4/6/2014. However, they appeared on 16/7/2014 and a petition seeking recall of the ex parte order was filed on 5/11/2014, and ultimately the impugned order was passed rejecting the petition dated 5/11/2014. The Learned Counsel submits that the reason for not filing the written statement on time is bona fide, and the proceeding itself was set ex parte prior to completion of 90 days from the date of service of summons. She has also submitted that there is no order by which the notice served upon the mother of defendant number 2 and wife of defendant number 3 was accepted as validly served upon defendant number 2 and defendant number 3 respectively. The Learned Counsel submits that the time limit for filing written statement is directory in nature and not mandatory, and facts and circumstances of the case was required to be examined by the court. The facts and circumstances under which the written statement was not filed is to be considered for accepting the written statement. She submits that the petitioners are also ready to pay some cost for as may be fixed by the court. The Learned Counsel for the respondent has opposed the prayer and has submitted that in spite of having appeared on 16/7/2014, the petition seeking recall of ex parte order was filed only on 5/11/2014. The Learned Counsel has also submitted that the impugned order does not call for any interference. After hearing the Learned Counsel for the parties and upon going through the materials placed on record, it appears that the order dated 4/6/2014 reveals that this indicates that the court recorded that there has been proper service of notice upon the defendants on 24/3/2014, but the defendants had not appeared in spite of knowledge, and the proceeding was set ex parte by the same order. However, the defendants by the same order, and the next date was fixed on 18/6/2014. On 18/6/2014, the matter was adjourned for ex parte hearing and it was fixed on 16/7/2014. On that day, the defendants filed their wakalatnama and also filed written statement, along with the wakalatnama.
Was not accepted.
But the same was not accepted. Thereafter, the case was fixed on 13/8/14, 10/9/14, and then on 5/11/14, a petition was filed for recall of ex parte proceedings, which has ultimately been rejected by the appeal. The impugned order itself reveals that the defendant number 1 was suffering from medical condition and the notice upon defendant number 2 and 3 is said to have been served through their mother and wife respectively. And it was the case of the defendants that they were attending to the medical condition of the defendant number 1. It appears that upon filing of the wakalatnama, they filed their written statement, but there has been some gap in filing the petition seeking recall by which the proceeding was set aside. This court is of the considered view that there was sufficient explanation placed on record for not filing the written statement within 90 days, within 30 days or within 90 days from the date of service of summons. The fact remains that the summon upon defendant number 2 and defendant number 3 were not personally served. Rather, it was served to the mother and wife respectively. And there is no order by which the notice served through mother and wife is accepted as validly served. There is no such judicial order. Considering the totality of facts and circumstances, this court is of the view that the impugned order refusing to recall the ex parte proceedings and to accept the written statement consequently calls for interference under Article 227 of the Constitution of India. The impugned order dated 16/9/2015 is hereby set aside. Subject to payment of cost of rupees, कितना cost लगा? 15,000 to be deposited by the petitioner before the court within a period of 1 month from today. The cost should be immediately remitted to the plaintiff upon due identification. The Upon payment of costs, the written statement be taken on record and parties to proceed as per law. At this stage, it has been pointed out that the petitioner number 1 has expired. She has expired, it has already gone.
Yes, sir.
She has expired. The fact remains that petitioner number 2 and 3 are the sons of petitioner. This aspect of the matter we also take it care of at the learned court. Communicate. ये वाला हम रख ले रहे हैं, इसका एक पैराग्राफ डाल देंगे इसमें से, इसका ना एक पैराग्राफ ले लेंगे. दिस इज पैरा नंबर 27.
Item 11, WPC 576 of 2012.
Case was that he had been working in Surat since Your Lordship April 2001, and in May 2002, when he had gone to his house, he found his wife to be in an advanced stage of pregnancy, and on 5th of May she delivered a child. So he filed an application that the DNA test should be done. That has been rejected on the ground that 112 of Evidence Act there is a presumption that if the child is born during the subsistence of the marriage or within 280 days from the date of dissolution of marriage, it has to be presumed that the child is born out of the same wedlock, and unless there is a very clinching evidence, it should not be disbelieved. This issue has recently been considered by the Honorable Supreme Court in some of the judgments.
The petition for DNA test has been rejected.
Rejected. The Honorable Supreme Court is of the view now, in view of the recent judgments, that when 112 Evidence Act was formulated, that time nobody speculated that such kind of test would be there. Now when there is a test and if the parties, nobody leads any petition or files any petition, then the presumption will be there. But if a party files a petition and when there is a scientific method to determine, then Your Lordship, that has to be done.
Presumption is a rebuttable presumption.
Rebuttable. Second, Lordship, the learned court below has also relied upon a judgment of the Honorable Supreme Court and said that forensic evidence, it is the discretion of the court whether to accept or not to accept.
आएगा तब ना accept or not to accept.
जी.
Unless it comes, how do you accept or reject?
Reject. So ये दो judgment है 2015 Volume 1 SCC 365 and 2014 Volume 2 SCC 576. जिसमें रिलाई किया लर्नड कोर्ट में वो नार्कोटिक सब्सटेंसेस है. 2015 का जजमेंट में लॉर्डशिप कैन कम टू पैरा 13 onwards.
2015.
जी.
Yes.
Para 13 would be in page 370.
Yes, I know.
All the judgments relied upon by the learned counsel for the appellant were on the point subject to the legitimacy of child born during the subsequent of married marriage. The question that arises for consideration in the present appeal pertains to the alleged invalidity of the appellant's wife. It is not the husband's desire to prove the legitimacy of child born of the appellant. The purpose of the respondent is to establish the ingredients of section 13(1) Roman 2 of the Hindu Marriage Act, namely that after solemnization of the marriage of the appellant with the respondent, the appellant had voluntarily engaged in sexual intercourse with a person other than the respondent. There can be no doubt that the prayer made by the respondent for conducting a DNA test of the appellant's son, as also of himself, was aimed at the alleged adulterous behavior of the appellant. If in the determination of the issue in hand, undoubtedly, the issue of legitimacy will have to be incidentally involved. Therefore, insofar as the present controversy is concerned, section 12 of the Evidence Act would not strictly come to play. Thereafter, Lordship, the Honorable Supreme Court considers the various judgments from para 15 onwards. And speaking thereafter, Lordship can come to para 17. So all the judgments, I am not reading all the judgments.
That's right.
The question has to be answered.
Yes.
The question has to be answered in respect of the alleged infidelity of the appellant.
Para 17.
17.
We may remember.
But para 17 is question has to be answered.
Okay. Para 17.
That para 17 is the part of another. Question has to be answered in this case is in respect of the alleged infidelity of the appellant wife. The respondent husband has made clear and categorical assertions in the petition filed by him under section 13 of the Hindu Marriage Act alleging infidelity. He has gone to the extent of naming the person who is the father of the male child born of the appellant wife. It is in the process of substantiating in this allegation of infidelity that the respondent husband has made an application before the family court for conducting DNA test which would establish whether or not he had fathered the male child born of the appellant wife. The respondent feels that it is only possible for him to substantiate the allegation leveled by him of the appellant wife's infidelity through DNA test. We agree with him. In our view, for the DNA test, it would be impossible for the respondent husband to establish and confirm the assertion made in the pleadings. We are therefore satisfied that directions issued by the High Court, as they have been extracted herein above, are fully justified. DNA test is
Okay. Now, what is the para?
17.
17. Yes.
We may remember that section 112 of the Evidence Act was enacted at the time when modern scientific advancement and DNA tests were not even in contemplation of the legislature. The result of a DNA test is said to be scientifically accurate. Although section 112 raises a presumption of conclusive proof on the satisfaction of the conditions enumerated therein, but same is rebuttable. The presumption may afford legitimate means in arriving to an affirmative legal conclusion. With the truth and facts is known, in our opinion, there is no need or room of any presumption. Where there is evidence to the contrary, the presumption is rebuttable and must feel the truth. The interest of justice is best served by ascertaining the truth, and the court should be furnished with the best available science and may not be left from the bank upon presumptions unless science has no answer to the facts. In our opinion, when there is a conflict between conclusive proof envisaged under law and the proof based on scientific advancement accepted by the world community to be correct, the latter should prevail over the former.
That's right.
So if it can decide the entire case, if that is in their favor, this is
Let us see the interview order.
yes.
Where is the written statement? You had filed a divorce
I have
case.
filed the suit.
Where is the suit plate? And where is your plea that you had no access?
Yes. Person kindly come to annexation of that document.
Annexure 1, I'm there.
That the marriage was solemn.
Yes, I'm there.
Can I come to this directly to the
Yes, you just
para
specific.
5 and para 6.
Para 5 and 6.
The plaintiff went to Surat in the month of January 2001 to join his job, where he was engaged in a private firm and lived there till April 2002 and came back to his home on 3/5/2002. But he went to his Sasural where he met the defendant and found her in the advanced stage of pregnancy and came back to his home. The plaintiff, finding the defendant infidelity, called upon the Panchayat on 5/5/2000 where in the presence of Panchayat, the defendant and her parents accepted the adulterous relation of the defendant. The defendant gave birth to a male child of the illicit relation on 1/6/2002.
Is there any other person as party in the proceedings?
No.
Now, 1/6/2002.
Also, from January I was not there.
That's
May
right.
I had come, and June she had given birth to a child. So last 9 months I was not here.
And where is the written statement?
Statement is not there. Annexure 2 is the application filed by me. And Annexure 3 is there.
Then what is the nature of interview order? When did you file your application for DNA test?
So this was filed on, just give the date, 3/2/2012.
And the suit is of the year
At the stage of
2000.
evidence. So that is the appropriate stage of evidence.
The suit is of the year 2008. And what is the reason assigned by the court not to
Yes, actually,
allow?
for the judgment order, the relevant question is
Page 37.
page 38. Also, just also last paragraph, upon evaluation of the facts of the case, it is clearly emerges that there has been a continuation of valid marriage between the parties. Just above that, learned court will have discussed 112 of the evidence and thereafter. On evaluation, it is clearly emerges that there is continuation of valid marriage between the parties which has not been legally dissolved as yet, and admittedly on earlier occasion. Two, the plaintiff also raised the question about paternity of the child, which was rejected by the court in DT upon the consideration of rigors of section 45 of the Evidence Act raised by the learned counsel for the petitioner. Same was also not tenable in view of the decision of the Honorable Apex Court in the case of Amar Singh versus State reported in 2005 volume 7.
Which petition was earlier rejected? In the same
In a criminal
proceedings?
case. In a criminal case also. And also
What do you
this
have to
judgment
say,
is
Mr.
with respect to narcotic substance and narcotic
What do you have to say?
Well, much has to say now.
Why are you shying away from the test?
Because the London court below was after taking into consideration the various judgments of the Honorable
Various
Supreme Court.
judgments, बताइए ना कौन सा
Yes,
judgments?
ma'am. My lord, may kindly see the finding portions, finding portion, my lord. It starts from page number 35.
Page number 35. Yes, heard both the sides.
Yes, very.
Yes, please read.
Heard both the parties at length and also perused the case report. From perusal of the report, it will be transcribed that indeed the present suit has been filed by the petitioner seeking divorce under section 13 of the Hindu Marriage Act from the respondent, essentially on the ground of adultery. Significantly, however, in his divorce petition, the petitioner, although charged his wife respondent for infidelity, has not made the alleged illegitimate child a necessary party as co-respondent and has merely leveled allegation of respondent having given birth to a male child out of the adultery because he never cohabitated with the respondent during relevant period. Yet indeed not substantiate his non-access with the respondent during the said period. The settled law proposition of is that the burden of proof lies on the person who alleges rather than the person who is in the.
Please, Mr. Das, just tell me one thing. Child is a necessary part.
Child is not a necessary party in matters related to dissolution. of-
No, but the point is, when you want the child's DNA to be tested, his DNA is to be
His
tested.
DNA is but he is not a necessary
Why
party.
not he is not a necessary party? Because his legitimacy is under cloud. His legitimacy is under cloud. Then how the child may be through the guardian, but child has to be a party in the proceedings.
Normally, is the in a case for dissolution of marriage.
Can
there
you
is no
force?
judgment-
Can you force a child from giving his suppose
No,
the point is how this DNA test will be conducted if he is not a party. He is not a party to the proceedings. Like you see, normally adulteress is also made a party.
Child is a yes.
Even adulteress is made a party in the proceedings.
Adulterers will be a party.
Will be a party
If he is identifiable.
if he is
Yes.
identifiable, right? Now the child is not a party.
The child-
How will the court enforce its order against the child?
Actually, if somebody is not only child, any person, if there is a direction of a court to give a sample.
No,
voice sample
that
or
is
any-
privacy of the child is affected.
No, if he refuses, he has the right to refuse.
No,
Then adverse
there is no
presumption has
question.
to be
No,
given.
no. He is not a party to the proceeding. His identity, his legitimacy is directly in issue.
Yes, but all the judgments have given in lordship. Child was not a party.
We do not
Lordship
know.
said we can do further research also on that, but
No,
child is not a
research is required. We will not permit this. Child is not a party in the proceedings.
child is not required to be a party. That
He has to be a party. because-
matrimonial suit also as a matrimonial suit, child will not be a necessary party.
Child, you see, in a case like this, where DNA test is to be conducted, and that cannot be conducted. You cannot force anybody to give his DNA sample.
Yes, even if he's a party, I cannot force. Court can
No,
direct.
no. If he is a party, the court can force.
But
The
the
court
law
can
is-
direct a party to
That
give.
if court directs a party to give a sample, he refuses, then court can
Take
take an
adverse inference if he is a party to the proceedings.
Actually,
But if he is not a party to the
in the
proceedings,
civil court, if I am not claiming any relief against the child,
no, you are claiming a relief against the child, directly or indirectly, because his evidence will come into play, his evidence will be there, his legitimacy is under cloud, and that is under grave question. And this, just a moment, this is of the year 2008. कितना साल का हो गया बच्चा?
जब हुआ तो उसमें तो माइनर था.
ठीक है, माइनर था. आज आप एक किसी को फोर्स कर सकते हैं डीएनए टेस्ट के लिए, and you did not even take any steps to make him party. Although this particular order is reflecting that one of the reasons for not permitting this test is that child is not a party to the
Lordship,
proceedings.
just see all both the judgment, we just taking care of several other judgments on that issue. In none of the cases, the child is a party.
You see, if none of the cases, in none of the cases, child is a party, that does not mean that we will not examine.
Whether child is a necessary party.
Yes.
Lordship, that issue, Lordship, if your Lordship gives it tomorrow only, Lordship, I will give the judgment that child is not a party. Lordship, there are various instances where this issue was raised. Child is not, both judgments are raised. Child will not be raised.
Now this particular lady, now this, if we pass an order now, right? The child is a grown-up child by now. Correct? He is born in the year 2001. The
So,
suit.
in view of the changed circumstances, because I came
Just a
to
moment.
this court, yes.
He is born in the year 2001. Correct? 2001 की कौन सा date में?
2002.
2002.
2002.
The matrimonial suit has been filed in 2008.
Yes.
Right? उस समय नहीं दिमाग का घंटी बजा. उस समय नहीं आपका बत्ती जला दिमाग का कि मेरा ये बच्चा कहाँ से आया? 8 साल बाद आपको होश आ रहा है.
नहीं 8 साल नहीं, उसके बीच में पंचायती के रिकॉर्ड में हम लोग सप्लीमेंट्री एफिडेविट में लाए. पंचायती में लोग पेरेंट्स का सामने ये एडमिट किया था कि हाँ हम लोग से गलती हो गया. Then they did not proceed for the mutual divorce. Then we filed it. And those things we have brought on record by your supplementary. Now
2001 का बच्चा कितना 20 साल से ऊपर का हो गया ना?
अभी हो गया, लेकिन जिस दिन फाइल किए थे 2012.
लेकिन ऑर्डर तो आज ही होगा ना?
नहीं, आज होगा तो definitely in view of the changed circumstances, Lordship में direct.
We cannot force a child to give his DNA sample.
No, Lordship can pass an order that he should be made a party.
Why should I pass an order to make him a party
In
under
view of the changed
227?
circumstances.
In 227, why will I pass an order?
227 Lordship is ample
No,
power to
no,
say that.
I don't exercise my power in
Otherwise,
such
your
a
Lordship, yes.
manner.
Otherwise, Lordship, child is Lordship in the cases of
When the impugn order says that he is not a party to the proceedings, you do not take any steps to make him a party.
other ground, it has been rejected also on the ground of
Maybe
112.
if there are 10 grounds,
Yes.
if one ground is sustainable, matter ends.
Yes, but child is not a Lordship. I will satisfy your Lordship. Let it come tomorrow only, Lordship, I will satisfy your Lordship. There are old judgments also, and Lordship, it is continuing till that the child is not a necessary party in a matrimonial suit.
No. Child is not a necessary party in a matrimonial suit, well accepted. But when you are seeking DNA test,
So DNA test is an evidence where Lordship no relief. Lordship, I will
DNA test is an evidence. But how will the court enforce that evidence? How will the court collect that evidence if the child is not a party before the court? Child would say, I am not bothered about it. I am not a party to the proceedings. Why should I give my sample? Can the court enforce such an order? Can the court, suppose there is a
Court cannot,
case.
Lordship, suppose I am a party also, Lordship, there are judgments to that effect. If I am a party also, for example, court directs that you give a bicycle, I refuse. Court cannot execute it
Court will.
by force.
Court
will
will-
take an adverse presumption.
That's right. But how will the court take an adverse presumption or assumption or whatever inference in connection with the person who is not a party to the proceedings?
That time, Lordship, in 2012, when the case was filed, or when this honorable court stayed the proceedings, that stage, child was not in a position to take any decision, either to refuse, not to. She was under.
See, even if the child is not in a
Child was
position to
under the
take
law.
the decision, the child becomes
Child
a
was under
party
the law.
through the guardian. Children, they do become parties.
Direct judgment, but in the changed circumstances, because the matter remained pending from 2012 and there was an interim order in our favor. In the changed circumstances, Lordship is right, their child can be made a party. But they will move an appropriate application. Yes. But Your Lordship, that cannot be a ground to deny me. Because in 2012 he was not a necessary party.
You tell me that he is not a necessary. Because one of the grounds which has been taken by
Yes,
the court.
that is an erroneous ground. So there are direct judgments that child is not a necessary party.
Even for
In
enforcing.
the cases of adultery.
Even for enforcing a
Yes.
DNA test.
DNA test is because he was under the lawful guardianship of the mother. The
Even
mother
for
is, the consent is-
even for enforcing a
Yes,
DNA test, he is
Lordship,
not a
I'm just
necessary
satisfying
party.
you, Lordship. If the child is a minor in the lawful custody of the other side, Lordship, it is the consent of the guardian which is Lordship necessary for DNA test, whether to give the sample or not, as long as he is a minor. Now the circumstances are changed due to pendency of this case. Now the situation may be different, but that as a counsel I also feel when it has come from your Lordship that at this stage, but on that time there was no error on our part in not making him a party. That I satisfied
Satisfied,
there
I am
are
not
direct
satisfied
judgments.
with
Yes.
that. Even if he is a minor, he has to be made a party.
The joinder of parties also, if the Lordship says it is a persons from against whom relief is being sought are necessary parties.
Relief is being sought.
No, relief is being sought against the mother. Lordship, therefore, Lordship,
Relief is being sought against the mother
Yes.
on the point of adulteration,
Adulteration.
but it has a very, very direct impact on the legitimacy of the child. So therefore, relief directly or indirectly is sought for against the child also. Because you are going to deprive him of many things. You are going to deprive him of many things.
Yes, he will. Things goes against him, he will not be entitled for inheritance also.
Nothing.
Yes.
No maintenance, no inheritance, nothing. And he will be a child without a father. Without a father's name. Very serious consequences.
But can you see the other aspect? When I am saying there are evidences that there was no.
You prove it through oral evidences, whatever. But
Sir,
when it comes to
satisfied that
enforcing a DNA test, I don't think that.
No, sir, as long
child
as
is not
he is a minor,
No,
Lordship, see all the
no.
judgments.
Even you see, when in a case of maintenance, right? When a mother is seeking maintenance for the children, children are also made parties.
Made party through, yes, but you know, in
Through
this-
through mother.
Through mother, yes.
So when you are seeking a DNA test, why the child will not become a party? Through the mother.
Lordship, yes. Lordship, I'll give the judgments directly. And this apart, your Lordship, the judgment which I have referred in those cases also, child was not a party. Lordship, can you-
Even if in those cases child was not a party, that will not decide the ratio of this case.
No,
When I am
sir, this
exercising
case
my
was
power
direct
under
judgment.
227, I will see the reasons which has been
Yes.
assigned by the court.
Lordship, I'll satisfy.
One of the reasons is that he is not a party.
Yes, I'll show the judgment directly to that child is not required to be made a party in a case seeking divorce on the ground of adultery.
The learned counsel for the petitioner during the course of argument has submitted that the learned court has taken note of the fact that child is not a party to the proceedings by rejecting the prayer for DNA test of the child. He submits that for enforcing DNA test in a matrimonial suit relating to adultery, the child is not a necessary party. He submits that the matter be placed tomorrow so that he may cite certain judgments. आप भी खोज के लेके आइए भाई, ना silently मत चलिए. It is something very serious, and this will decide the jurisprudence on the point. It is very, very important. It is extremely important. आप किसी आज के दिन में 20-25 साल के लड़का को बोलिए कि आप डीएनए टेस्ट दे दीजिए.
आज circumstances
आप
change हो
अपने
गए.
आप को रख के देखिए उसकी जगह पर. How will you feel about it? पूरा उसका record, you see, पूरा school record. You just look at it, Mr. Das. पूरा school record, पूरा उसका identity in the society is at stake.
Circumstances change हो गया अभी because Lordship, in 2012 when this case was filed, the circumstances were different. Now the circumstances have changed when the
Since the circumstances have changed, still the court,
No, therefore Lordship.
still the court can refuse to interfere with the order.
No.
Even recording that circumstances have changed to such an extent.
This is one part, and Lordship may otherwise also say that in view of the changed circumstances, Lordship may permit us
No,
to
no, no, no.
and issue notice and
We
hear
will
what
not
the
permit
thing
you.
is.
हम लोग को नया कहानी थोड़ी शुरू करना है यहाँ.
No, in view of the changed circumstances, I can, because there was a stay order in my favor.
उसके लिए आपको कुछ और ही हायर कोर्ट पे जाना पड़ेगा. हमसे नहीं होगा. हम नहीं करेंगे. Unless you show me very some binding precedents on this,
Yes.
that without making the child a party, DNA test has to be conducted, I will not permit this.
There is one more important. So the same cause number, one petition was filed before the SDGM for
That was
DNA.
in a criminal case.
That is in
But that was rejected.
That
was rejected. Thereafter, the criminal revision was filed. That was also rejected. So, the finding of the court.
No. Not in a matrimonial suit. You cannot draw any parallel.
हम 498 में
मतलब वो भी DNA के लिए था.
No, but
That
हाँ,
petition
DNA
was
के
filed
लिए
for the
किस
DNA
circumstances में फाइल हुआ, that is a separate thing altogether. उस पर कोई रेस्ट ड्यूटी काटा नहीं लग सकता है. Different nature of proceeding है, but it is certainly very important. थोड़ा सा काम करिए.
For a time ready.
वो गोराई जी को बुलाइए. हमको भी तो रिसर्च करना पड़ेगा ना. ऑर्डर तो हमको साइन करना. गोराई जी को जरा बुलाइए. करिए अच्छे से रिसर्च करिए. Jurisprudence भी खोजिए.
Decision हमारा that is if the prima facie.
Because at least some decision has to be there. It is a recurring problem. कोई बात, हम कहाँ बोल रहे हैं कि आपका सबमिशन आप लेके आए.
Child is not required to be made a party. Address if his identity is known, he is required to be a party. If identity is not known, then he cannot be.
Then my lord, she was living in adultery with the entire region because that has been stated in the petition.
We'll see that. Mr. Das, बहुत serious implication है. बहुत serious implication है. पर्सन के प्राइवेसी का.
दोनों तरफ से सीरियस है.
हाँ, दोनों.
Father will be asked to maintain a child knowing fully well that he is not.
अब तो मेंटेनेंस का भी कहानी खत्म हो गया ना. 25 साल का हो गया वो. कहीं काम कर रहा
Maintenance,
है.
inheritance सभी चीज. हम मर भी जाएंगे तो मेरा
दादाजी का फर्स्ट केस. प्रॉपर्टी से क्या ही होने वाला है. आइडेंटिटी इज वेरी इंपॉर्टेंट. पूरा स्कूल का रिकॉर्ड में आप समझ रहे हैं.
तो एक तरफ है, दूसरा तरफ मेरा प्रेडिकमेंट कि
क्या?
I being the knowing fully well that it is not my child. I was in Surat and I am said to be father.
कोई बात नहीं. आपने ऐसी लेडी से शादी किया है तो क्या करेंगे. आप 2 साल के लिए बाहर चले जाएंगे तो शी इज बाउंड टू गो एडल्ट्रेस. मत कहानी सुनाइए हमको. 2 साल के लिए बीवी को छोड़ के बाहर चले. फेयर है. यू शुड हैव टेकन हर.
Circumstances गरीबी जाता है और circumstances जाता है कि अपना जगह बना के
इतना गरीबी था तो शादी नहीं करना.
नहीं तो आया सब मैं इसीलिए तो आया लेने के लिए 2 साल में.
चलिए.
This case item 13, WPC 496 of 2016.
By the imperial lawsuit,
Hmm.
the petition filed by the plaintiff under order 6/17 CPC seeking amendment in the plaint has been allowed when the case was posted for final hearing of the case.
What is the nature of amendment?
Also in Annexure 3, page 31.
Where is the amendment petition? Page 30.
31.
Pardon.
Proposed amendment lawsuit, after para 5, the claim the following para 5 be added, that the Rekha Singh and other, the vendor of the defendant, had no right and title to execute any deed in the year 1981 to any other person with respect to the suit land when the Rekha had earlier executed a sale deed in the year 1972, that is used by1 in favor of the father of the plaintiff number 2 and 3. The plaintiff in order to avoid any complicity with respect to sale both sale deed number so and so in their favor in order to continue the possession and the title earlier acquired by the exhibit B by 1 law.
आपको ये पता नहीं था पहले?
नहीं, हम डिफेंडेंट्स हैं.
हाँ.
प्लेंटिफ का हुआ.
This has been allowed.
It's allowed. It is barred by the limitation law. The suit was filed in the year 2010, and the purpose of he is challenging the sale deed executed in the year 1981 to be barred by limitation law.
ऐसा है ना कि अगर मान लीजिए पहले से सेल डीड हो गया होगा, बार्ड बाय लिमिटेशन का काम नहीं होगा इसमें, क्योंकि अगर पहले से सेल डीड होगा उसको टाइटल ही नहीं है तो बात खत्म, इसलिए बार्ड बाय लिमिटेशन नहीं होगा। मिस्टर गोदाई, वो एक थोड़ा जजमेंट कीजिए, डीएनए टेस्ट जब होता है बच्चे का तो मैट्रिमोनियल सूट में भी जैसे एडिक्ट्रेस को पार्टी बनाते हैं ना, उसी तरह से चाइल्ड को क्या पार्टी बनाना ज़रूरी है टू एनफोर्स डीएनए टेस्ट, पैटर्निटी टेस्ट के लिए, ठीक है? मिलेगा कुछ पार्टी उसको बनाना ज़रूरी है कि नहीं तो हम लोग एक कैसे एनफोर्स करेंगे इस ऑर्डर? इससे लिमिटेशन का बात नहीं है इसमें। And what is, where is the order?
Lecture 5 also,
Ready?
page 36.
A rejoinder has been filed. पढ़िए ये मिस, a rejoinder has been filed on behalf of the defendants.
By the amendment of this petition, the original title has executed the sale in favor of Sadhu Miya, but surprisingly enough, the sale was not acted upon which no consideration was paid as yet. In the deed itself, it has been stated that consideration amount will be paid at the time of Tapaju per the line, but even today no consideration amount was paid to the vendor Ram Rekha Singh and other. Hence, they might register deed of cancellation. Can cancel the sale deed to execute it in favor of Sadhu Miya. So deed is going to cancel हो चुका है. The whole question is to decide whether the Sadhu Miya acquired any right title in possession through the deed as alleged in petition. हम लोग सुप्रीम कोर्ट देते as in judgment passing of the title depend upon the intention of party. And in this case, the intention of the vendor is to quite clear that until and unless the consideration is paid, no title will pass to the purchaser. In this case, up till now, the consideration amount was not paid by the Sadhu Miya to the seller. The recording title will not pass to the Sadhu Miya, which has been admitted by themselves as they claim their title to one lady, Khetri Miya. Meaning thereby they don't agree with the title placed with the Sadhu Miya, though neither the Sadhu Miya nor the Khetri Miya has got any right title interest in possession of the person claiming pursuantly to be dismissed from the assertion penalty through the assertion amendment filed on services in service. The sale deed in the year 1972 executed was already cancelled. And in lecture 36 of page 5. Page 37 of the finding. As introduced the record, this case is fixed for argument and petition has been filed 37/2020. This court is agreed that proposed amendment will not change the nature of the suit, but the considering the fact that the amendment is being filed very belated stage in the interest of the amendment petition creating the law subject to cost of rupees 2,000 to be paid to the defendant. Further will be liberty to defendant to file a
कुछ
defense.
नहीं आता। WPC number 496 of 2016. Heard the learned counsel appearing on behalf of the petitioner. Nobody appears on behalf of the respondents. The learned counsel for the petitioner has submitted that the petitioners are the defendants in the suit.
The petitioner is the defendant.
The petitioners are the defendants, some of the defendants in the suit, and they are aggrieved by the impugned order by which petition under Order 6 Rule 17 of CPC has been allowed at much belated stage when the case was fixed for arguments. Final hearing. The perusal of the plaint reveals that the suit was filed for declaration of right title interest over the suit property. Right title interest and possession over the suit property through based on title deeds, registered title deeds. The suit was contested and as per the order, as per the petition seeking amendment, it was asserted that from perusal of the documents of the defendants, it appeared that the vendor of the defendants had earlier executed a sale deed number 12415 of 1972 in the name of Sadhu Mia, the father of the plaintiff's number 2 and 3. And after execution of the deed, the sale deed number 4403 dated 7/5/1981 was executed in the name of the father of the defendant number 3 and 4. And it was asserted that Ram Rekha Singh had no title over the suit land for conveying any title to any person in the year 1981. Both the deeds were exhibited as Exhibit B/1 and B/2 by the defendants. And it was on the basis of these documents the amendment was sought for. To the following effect. ये आपको मिलेगा पेज नंबर 31 में, बॉटम में proposed amendment. This court finds that the learned trial court by impugned order dated 13/10/2015 has passed a detailed order allowing the petition seeking amendment in spite of the fact that the case was fixed at the stage of arguments. The court, while passing the impugned order, has taken care of the fact that the entire question involved in connection with the title was as to whether Sadhu Mia had acquired any right, title and possession through the deed This court finds that the learned trial court has passed a well-reasoned order allowing the amendment, and considering the fact that amendment had come at a belated stage, has also taken care to allow the amendment with cost, and has also recorded that the amendment will not change the nature of the suit in any manner. This court finds no illegality in the impugned order, which is well-reasoned one. Accordingly, there is no merit in this writ petition. Dismissed, interim order vacated, permanent. Since the matter has remained pending before this court since the year 2016, and the suit is of the year
2010.
and suit is of the year 2010, the learned court is directed to take steps for expeditious disposal of the matter.
Next case item 15, WPC 393 of 2015. In case we see separate
Actually, something again. Where is the petition? इसमें कोई एक डेट दिए थे ना किसी आपका केस हुआ है फॉलो नहीं आपका नहीं अपाक एंड मतलब सॉरी
नहीं वो इसमें नहीं फर्स्ट टू केस में
तो ये किसका केस
इसमें नाम मिस्टर श्रेष्ठ गौतम का
अच्छा
और मिस्टर शाह कुमार की
तो आप ये नहीं होते पिछली बार भी
पिछला एक लड़ी
ये किस हेडिंग में है किस हेडिंग में है
ऑर्डर्स
as per office note respondent number 4 has been reported dead. इसमें कौन सा आईए फाइल है
दो आइडियाज इंटरनेशनल ऑफ 5253 और 67
सब्स्टिट्यूशन भी फाइल हुआ है इसका इसका सब्स्टिट्यूशन फाइल हुआ है इसमें Substituted service of notice. Substituted service of notice. Six two seven zero. ये substitution लिख देते हैं. Substituted service of notice के लिए. Substituted service of notice. Indicate the respondent number 4 has been reported dead. However, a petition being ID number 6270/2015 has been filed for taking substituted service of notice upon respondent number 3 to 6. The notice upon respondent number 3, 5 and 6. 3, 5, 6 and 7 has returned unserved. As they were not received. Upon perusal of the petition, it appears that the petitioner has filed petition for substituted service of notice upon respondent number 3, 4, 5, respondent number 3, respondent number 4, 5 capital A, 5 capital B, 5 capital C, and respondent number 6. And as per the office note, respondent number 7 is also not received. In view of the aforesaid facts and circumstances, the counsel for the petitioner is directed to take steps for is permitted to take steps for substituted service of notice upon respondent number 3, 4, 5A, 5B, 5C, 6 and also 7. through newspaper publication in the following two newspapers. Telegraph, having circulation in Jharkhand and West Bengal. B. वेस्ट बंगाल में प्रभात खबर चलता है, प्रभात खबर चलता है वेस्ट बंगाल में, छपता है, मालूम है प्रभात खबर छपता है वेस्ट बंगाल में, हाँ, एंड प्रभात खबर having circulation in Jharkhand and West Bengal. The respondents in connection with whom the substituted service of notice has been ordered are resident of Palamu district / Hooghly, West Bengal. एक तो न्यू दिल्ली के हैं, रिस्पॉन्डेंट नंबर 3. ये करिएगा और रिस्पॉन्डेंट नंबर 4, 5A, 5B, 5C, 6 and 7, है ना? So far as respondent number 3 is concerned, she is resident of New Delhi, and accordingly the substituted service of notice being published in Hindustan Hindi Daily and Hindustan Times English Daily, having circulation in New Delhi. The draft notice for publication be furnished by the petitioner in the registry within a period of 10 days from today, failing which this writ petition shall stand dismissed without reference to a bench. If this order is complied within the stipulated time, post this case on 11th of May, (2026). The supplementary affidavit annexing the newspaper publications be filed latest by 7th of May. In case this order is not complied, the office is directed to dismiss the writ petition and communicate the order to the court concerned so that the court may proceed to decide this. Communicate कर दीजिए petitioner के वकील को. For last 3 days he is not coming. Stay लेके सब घूम रहे हैं.
Item 1 WBC 332 of 2003 along pattern.
Yes, madam.
This written sentence SR which ordinary the petitioner is claiming the land on which Chabalwadi Radhika's matter was heard partly on 1st July Lordship and we have been instructed to file Khadyan which says it's of Chabalwadi nature Lordship. The rent receipt has already been annexed to Lordship and is now also before the Lordship. We have not been able to file any other Khadyan Lordship.
So whatever it is, you are doing.
1 week's time.
No, we are. You see, these are no. You have. You see, on the last date, you said that you will prepare notes also.
No, we have prepared the notes, Your Lordship.
So you are. You have the notes. You have prepared already.
We have to file the
No.
corrections.
No.
Just one.
Correction slip has got no value.
Your Lordship, the rent
Correction slip, rent receipt may not have any value.
Your Lordship, it says Chabalwadi.
SCR case. What do you mean? Chapparwali nature.
Your Lordship, then the CMT section 71A would not apply on this.
It will apply. Your rent receipt will show Chapparwandi and we'll take it as Chapparwandi.
Your Lordship, that is why I'm just seeking 1 week's time.
No.
This
No, rejected. I will dismiss it right away. Since 2003, what are you doing?
Your Lordship, we have also argued this matter. on
So
the
what?
dates, Your Lordship.
So you have to argue. No. On several dates you might have argued. I don't know if I have heard it ever. I must have heard it. Then hear it.
I mean, Your Lordship, it was well coordinated.
No.
Your Lordship, one last opportunity.
No. I'll impose cost, heavy cost.
After 2 days of payment.
You see, I heard it on 18/1/2018. You see? Within 1 month I was elevated. I heard it. And now I'm about to retire. Of course.
At least
No.
Your Lordship, on Friday or Monday, Your Lordship.
No.
Last.
No, I will impose cost.
Your Lordship,
I will give you
one
time.
last opportunity.
Of course, last opportunity.
Your Lordship, one last.
No.
For 2 days, Your Lordship.
I will give you 2 days, but with cost.
Your Lordship, 2 days.
Not without a
Your
cost.
Lordship,
Madam, please don't argue like this. There is no advance notice seeking adjournment. It's the first case on the board. Did you give? So, how you have become so irresponsible? You want time? I'll give you time. Instructions for what? And I can hear it every day.
Yes, Your Lordship.
Every day from tomorrow, every day till it is over.
Your Lordship, just
No.
on record.
You will not get an adjournment without cost.
We have to say it, Your Lordship, come on to the next.
Sale deed is of no value in SAR case. You just come.
Item 3 WBC 3994 of 2004.
There's some personal issues that are agreeing on this, not aware.
Prayer rejected. Yes.
Similar issue has already been decided up to the billion regions.
Right.
What is the first one we have taken? They already sent the mail.
Mail to whom? आपके पास कोई मेल आया है इसमें? What time?
1 week.
2004 matter, we are not going to adjourn it like this. These are 20 years old matters. We are under a lot of pressure because of you.
1 week.
1 week. You prepare yourself. I will not give you time. Let him argue. You answer it tomorrow. But let him argue this case. Yes, yes.
Email is the report.
Yes.
Earlier reports.
No, first let us see the facts. What is the impugn order?
Worship, we paid for causing the demand notice issued by the railway authorities demanding a sum of ₹2,74,000 loss. It was alleged excess loading in respect of 17 wagons of stone chips booked on 1/1/2000 from Barawa railway station to Siman railway station, being wholly illegal, arbitrary and without. Second phrase is declaring that the railway has no authority to levy or recover penal freight after delivery of goods without objection.
Oh, they delivered the goods without objection.
Yes, ma'am. Earlier they delivered. Subsequently, when I again booked consignment, they said that earlier one there was excess, and that payment was behind my back.
Okay, let us see. Where is the impugn order? Where is the impugn order? When was your first consignment sent? Show me the impugn order, please. They have filed a counter affidavit. What is their response to para number 11?
That under section 83 of the Railway Act, the Railway Administration has lien for freight on any other sum due to it, and the same can be realized on failure of the consignor, consignee, or the endorsee to pay the same on demand by detaining any consignment of such person whenever the same comes into its possession.
No, I just want to know what is the response to para number 11.
That I have read from the counter.
Para 9, 10 to 13 is 10 to 13 is one reply, single reply, isn't it? Read para number 20 of the counter.
That in reply to paragraph 10 to 13, it is stated that under what circumstances the payment chart was not sent to destination with vehicle guidance is a matter of inquiry by the respondent, but the same cannot wipe out the cumulative demand raised by the respondent under section 73 of the Act for overloading.
So it is an admitted fact that the goods are given to you without any notice. No, without any allegation that it was overloaded.
Same similar issue has been already decided by the.
Where is the impugn order? Annexure 3.
Annexure 2 also.
Which is 3 perhaps. 6,34,701. Right, this is the figure. Rupees 2 lakhs. Annexure 2. You place annexure 2.
For different consignors. For the least petitioner, it is just stated in paragraph 8. ₹2,74,000. Paragraph 3.
When was the goods delivered to you? 9/1. Your name is Krishna
Stoneworks.
Stoneworks. You read annexure 3 also.
In reference to the above mentioned subject, it is to inform you that the said undercharge has not been realized as destination till now. No any response has been received either by you or by destination station as a reply of my above letters mentioned in reference. Now, SM of Pararba has instructed to realize the said undercharge from you. Hence, you are requested to deposit the said undercharge along with freight of Seaman loaded on deck. Breakup of undercharge is as under. 2,74,960.
So at the time of delivery, since there was no demand, therefore section 83 does not come into play, and therefore the penal charges cannot be
And
realized.
the subsequent removal was done behind my back.
We are not bothered about you. They deliver the goods to you without any demand.
Division was also held that coordinate benches rightly held that there cannot be any lien, unfettered lien. May I please have the motion?
Yes, division bench, no APL.
Read also briefly brief honor as well as
83, you read section 83, it is quoted in the writ order.
yes.
If the consignor, the consignee or the endorsing.
If the consignor, the consignee or the endorsee fails to pay on demand any freight or other charges due from him in respect of any consignment, the railway administration may detain such consignment or part thereof, or if such consignment is delivered, it may detain the other consignment of such person which is in or thereafter comes into its possession. Subsection 1 is divisible into two parts. As this provision is separated by the word or, the first part is not applicable in this case because the first consignment had been delivered. The second part, according to railway respondent, is applicable. The question is whether this lien gives unfettered right to the railways to recover the dues by detaining the subsequent consignment. Relying on a decision reported in AIR 1998, SC 1959, the learned counsel appearing for the railways argues that this lien is wide and unrestricted. The lien arises out of same legal obligation to penalty by the consignee, etc. Therefore, in order to find answer to this, it has to be examined whether a legal right has accrued to the railways to realize the freight. By now, we have noticed that a number of safeguards in the form of rules 1740, 1820, 1737 and of section 65(2) instructions on the railway receipts giving a clear advice for re-payment before delivery, etc. have not at all been followed by the respondent in the spirit in which they should have been followed. We have also found that how due to lapses on the part of the respondents at every stage, right at the station of re-payment till the point of delivery of the goods, the negligence in complying with those provisions have been glaring. We have also found that in the aforesaid circumstances, the verification of the claim of overloading became impossible, and thus the claim is merely based on paper in the hands of the railway itself, and thus became suspect and amounted to violation of the principles of natural justice. The lien as stated under section 83 of the Railway Act Supra is a statutory lien. Statutory liens, however, have been looked upon with jealously and generally will only be extended to cases expressly provided for by the statute, and then only where there has been a strict compliance with all the statutory requisites essential to their creation and existence. I have already noticed that all the statutory requisites, Rule 1740, which are for safeguarding the interest of the railways and also for maintaining the transparency, has been most carelessly not complied with. consequently it has to be held that in absence of compliance of the observance of the statutory requisites, a lien is not created in favor of the
That's right.
respondent.
Yes, respondent. You are there? Yes. Argue your case.
Plus tomorrow it will
This order has been affirmed, so we already know.
Yes.
Your Lordship, we'll go through that order once it will come tomorrow, Your Lordship.
कवर्ड केस से क्या इसमें देखना है?
एक बार बस देख लेते हैं।
देख लीजिए आपके पास टाइम।
Your Lordship, it will come tomorrow, Your Lordship. As first
As
case.
फर्स्ट केस ऑलरेडी एक है। सबके पास टाइम ही लेने के लिए बैठे हैं। सीनियर लोग 2 दिन पहले नहीं आते स्टेशन में वापस
आ गए Your Lordship. कुछ पर्सनल डिफिकल्टी की वजह से जाना पड़ा, इसीलिए आज सुबह मिल गए Your Lordship. Just tomorrow, Your Lordship.
Okay, the learned counsel for the petition has submitted that the present case is squarely covered by the judgments rendered by this court in CWJC number 3191 of 2000 within bracket R, which has been upheld in LP number 132 of 2003 by judgment dated 22nd of November 2012. He submits that the entire consignment was delivered to the petitioner and subsequently penal charges has been raised.
Demand.
The penal demand has been raised by referring to section 83 of the Indian Railways Act. Counsel for the respondent submits that the petitioner has concluded his arguments. The counsel for the respondent submit that the matter be posted tomorrow for their response. Tomorrow एक केस है मिस्टर दास का, उसके बाद tomorrow at 2:50, right? Give your parents.
Notify case item 1, first appeal 175 of 2024.
This appeal is dismissed.
From date is item 4, WPC 4838 of 2004, along with item 5.
May I tell the story first? Short story of this case. But in 2001, on 18/9/2001, an inspection was done in my premises. But on 29, I go to my we went to the electricity authority and we said that there is some
You are challenging the bill.
yes,
You have a forum. Why do you need to challenge the bill over here?
it was the case of 2001, Lord. At that time there was no.
Now there is a forum. Every fact will be taken care of. Yes. They can agitate their case before the forum.
Yes.
ये बिल का डिस्प्यूट यहाँ लेके बैठे हो क्या? फोरम में आप अपना
इस
देखिए।
केस में FIR हुआ था। FIR
सेकंड केस के बाद में रेजुडिकेटा सेकंड केस
नहीं सेकंड केस रेजुडिकाटा से बात नहीं है सेकंड केस मतलब if during pendency of this case the further development was occurred they passed an order which they have annexed in their counter affidavit. They filed their counter affidavit in 2009. So we had to but we had no so we had to they submitted this order in 2009 So we filed an IA application in this case, and we had filed another writ application challenging that order also. So both cases are there. Facts are
Amendment has
absolute.
been allowed.
Amendment has been.
What was the nature of
The
amendment?
amendment said pending ही, IA is also pending.
एक वेकेटिंग स्टे है,
हाँ, और एक
2010 से वो भी चल रहा है,
हाँ, और
20 साल से वो भी 15 से।
केसेस
Stay
करने
vacant.
वाला था, बहुत बार बहस भी हुआ है।
आप जैसे इतना बहस करिएगा तो इसीलिए meeting हो जाएगी।
2024 में तो 2-3
कुछ नहीं, अब हो गया, एडजमेंट का कहानी करता हूँ। अब आप बस हमको ये बताइए, ये बिलिंग डिस्प्यूट हम लोग यहाँ पे क्यों डिसाइड करें? Why should we decide a billing dispute over here?
दूसरा फोरम था इसलिए
अब है ना, अब है,
पुराना केस
नहीं पुराना केस करेंगे ना आप लोग
It will
डिसाइड,
be remanded by this court, of course.
करिए। बिलिंग डिस्प्यूट है, इसमें क्या करना है? बिल का ही डिस्प्यूट है ना।
बिल का डिस्प्यूट
अमेंडमेंट में क्या किए थे?
एक फैक्ट और है।
Amendment में subsequently we have passed an order in pursuance of order of this court, we have passed an order making a supplementary bill that has been sought to be checked.
नहीं हम ये ऑर्डर पास किए हैं। इनिशियली द बिल वाज ऑफ 98 lakhs and 86 rupees, and after that during pendency of this case they have passed an order, they have amended their own bill. Now the amount which I have to pay according to them, Lord, is 48 lakhs and odd. Now against this order, Lord, there is no bill. The order is only there.
You challenge that order, no?
No, we have challenged that order, but without any bill, how can we pay?
That bill has
This is
been
also-
reduced.
No,
Bill has been reduced, no?
Yes.
bill, the reduced bill has to be.
भाई चीफ इंजीनियर का ऑर्डर तो फोरम में किया जाता है कि नहीं किया जाता? Yes, Mr. Nitin. फोरम करेगा ना डिसाइड?
If it is a matter concerning theft of electricity, it cannot.
It is not.
Theft is out.
नहीं theft initially the
थेफ्ट का तो
was
कार्य
there.
खत्म हो गया, अब तो बिलिंग डिस्प्यूट है।
Only billing dispute is
You see, I tell you.
May I say? The theft was there according to them, Lord. In criminal court, Lord, the police filed final report, Lord. They were also examined and they said that they don't have any objection. And on that basis, the case was closed.
Case closed हो गया।
Now the bill is on the basis of theft only.
No, it is not like this. ऐसा नहीं होता है। वो criminal और civil अलग अलग चलता है।
Lord, they have raised this bill
You
on
see
the
now,
basis of.
I tell you. You are before the very top. आप चल जाइए फोरम में अपना सब चीज वहां पर सुलझा लीजिए, फिर तो रिट है ही आपके पास। You are not being rendered remediless, but why should I decide a billing dispute over here? You have an order, देखिए 2004 का ऑर्डर है, I can give you time कि भाई आप 2 महीना में फाइल कर दीजिए, 1 महीना में फाइल कर दीजिए। तो वो टाइम रहेगा तो आपका कोई टाइम बार का कोई मतलब ही नहीं है फिर फाइलिंग। And every aspect,
No, I cannot.
सब देखिए जो स्टैट्यूटरी रेमेडीज आपके पास अवेलेबल है, these are all technical issues. These are all technical issues. इसमें बहुत सारा कहानी है। नहीं है कहानी, बताइए।
दो इशू बस दो, ठीक।
आप अपना जाइए वहां पे अपना फरियाद कीजिए। This is absolutely billing dispute, यहाँ पर कुछ नहीं होगा। कब तक फाइल कर देंगे बताइए?
एक मिनट। बिल जो रेज किए हैं JMD एलॉयज वाले केस के बेसिस पे, लेकिन JMD एलॉयज का जो केस है ये केस कम्प्लीटली डिफरेंट है। JMD एलॉयज वाले केसेस में देयर वाज no person was noticed, no person of the board was noticed, No person came to the court, Lord, and on that basis, Lord, the case was closed. So the Honorable Supreme Court said that even after closure of that case, Lord, they can proceed with the realization of bill amount. Now in this case, Lord, they appeared, they said that they don't have any objection, and this case was a mistake of fact. All these things have been recorded in this case.
देखिए क्रिमिनल केस में आपका चार्जशीट नहीं हुआ, इसके बेसिस पे हम आपका ये इलेक्ट्रिसिटी
चार्जशीट नहीं हुआ,
क्लोज हो गया,
on their own basis. They said that this was a mistake of fact.
उसके बेसिस पर हम आपका ये नहीं डिसाइड कर पाए। 16.9 पर आपका बिल रेज किया, राइट?
इसमें JMD LOL में the board submitted that in the cases of theft law 16.9.a law would be applicable. Now in this case law they are calculating on the basis of 16.9.b.
नहीं, पॉइंट ए
B पे कर रहे हैं.
आप इस ऑर्डर को चैलेंज करते हैं, यू हैव एन एप्रोप्रिएट फोरम टू चैलेंज दिस। क्या नाम है इस फोरम का?
विद्युत उपभोक्ता शिकायत निवारण फोरम।
यू रेज द बिल। दूसरा क्या है?
दूसरा सेम
सब्सिक्वेंट बिल उसमें चैलेंज,
हाँ,
और इसमें सिर्फ
इसमें हम
काउंटर में आया,
इसमें हम IFI किए
तो एक ही बिल को दो जगह चैलेंज करेंगे।
That was my point. One will be brought by us.
ऐसे साथ साथ ये जो ऑर्डर हुआ है इसमें
दोनों केस सेम है। ये केस पहले फाइल हुआ, जब सब्सिक्वेंट एक ऑर्डर लाएंगे तो उसको हम लोग इसमें अमेंडमेंट डाले हैं, बिकॉज नो काउंटर एफिडेविट हैज बीन फाइल्ड इन द अदर केस। सो दिस केस वाज टू बी हर्ड लॉट, सो वी हैव फाइल्ड अमेंडमेंट एप्लीकेशन इन दिस केस।
you have filed an amended petition also.
नहीं, अमेंडेड इट नहीं।
You have filed the amendment for setting aside the order dated 31/8/2004. And here, this order of 31/8/2004 is under challenge. ये तो ऑर्डर का डेट ही नहीं लिखे हैं, आप क्या चैलेंज किए?
Because we say that this
ये
order-
किस पर्टिकुलर डेट पे WPC
6848
6848 में
not this
आपके प्रेयर में ऑर्डर कौन सा चैलेंज के नहीं लिखे हैं?
This, we say this, we have not given the date, Lord, because we say, Lord, we claim that this date was, Lord, antedated, Lord, they have put up this date after they have, please suppose this.
फिर भी कौन सा ऑर्डर है, कौन सा एनेक्शन है, वो तो कुछ लिखेंगे, वो भी नहीं लिखे। एनेक्शन कौन सा चैलेंज?
Yes,
Isn't annexure 13 which is under challenge?
yes.
Should I take it that it was annexure 13 which has been challenged?
Yes.
ये वाला WPC नंबर 4850 of 2001 का ऑर्डर 21/3/2003 का, वो कौन सा ऑर्डर है जो इसमें प्रेयर में ही लिखे हैं? You have written it in the prayer only. WPC number 4850 of 2001.
ये पहले का केस था।
किसका केस था? किसका केस था?
इसी का
इसी का केस।
इनिशियली जब ये इंस्पेक्शन डाले और FIR किए और एक बिल दिए हमको 21 लाख, उसको हम इस केस में चैलेंज किए हैं। उसमें इंटरिम ऑर्डर हुआ कि हम 6 लाख रुपया 12 लाख रुपया टोटल अगर हम दे देते हैं तो मेरा जो है डिसकनेक्शन नहीं होगा और हम करंट बिल देते हैं।
ठीक है, उसके बाद रिट पिटीशन डिस्पोजल हो गया, उस केस का क्या हो गया?
डिस्पोजल हो गया, उसमें कहा गया
कब हुआ ऑर्डर?
वो 21/1/2003 को डिस्पोजल हो गया।
21/1/2003 इसमें आपका बिल रेज हुआ था 21,62,756 और 12 लाख आपको पेमेंट करने के लिए बोला गया एंड देन दे वर सपोज टू डिसाइड इट afresh.
Yes.
ठीक है, that this happened, this was raised on in the year 2001, correct? 2001 में चैलेंज हुआ था WPC नंबर 4850 ऑफ 2001, करेक्ट? उसके बाद फ्रेश ऑर्डर कब हुआ?
फ्रेश ऑर्डर ये कहते हैं कि 31 अगस्त 2004, लेकिन जो पहला वाला केस है उसमें एक बिल हमको दिए हैं which is dated 1/9/2004, just 1 day after. In that case, you know, that is the bill of 98 lakh and 86 lakh.
Okay, then a follow-up bill.
हाँ, follow up है लेकिन डेट पहले का है।
ठीक है, antedated or whatever. There was a follow-up bill, which
बिल
is
है ही नहीं, ऑर्डर है।
follow-up order, right? Followed by a bill of 98 lakhs.
नहीं, 98 lakhs का बिल हमको पहले मिला, which I challenged in the first case, that is 4838 of 2004. और उसके बाद काउंटर में दूसरा लेके आते हैं। बाद में हमको ही पता चलता है कि 31 अगस्त को ही एक ऑर्डर आ गया है जिसमें 43 lakhs एंड ऑर्डर हैज टू बी पेड, बट उसके लिए कोई बिल नहीं आया।
Bill नहीं आया है, but according to that order, the dues are only 43 lakhs and all, which you are challenging the subsequently, right? This is the entire.
हाँ,
इसमें कोई लीगल प्रॉब्लम है फोरम में डिसाइड करने में? बताइए।
First read, in that case, the first read will become infructuous. So all the
क्या भी इंफ्रक्चुअस होगा, यही कहानी लिख देंगे इनका पूरा कहानी।
In second
2001 से लेकर 2004 तक का कहानी लिख देंगे, right? This is essentially billing disputes. Lot of facts are to be seen
Exactly.
and consider the जिस आप लोग का जो टैरिफ है उसको भी कंसिडर करके ही ऑर्डर होगा। There is no problem. There is no problem. Otherwise, they can challenge the order. They can challenge the bill. Both.
Both.
ठीक है, अगर सब्सिक्वेंट बिल नहीं भी आया तो भी चैलेंज कर सकते हैं, ऑर्डर को चैलेंज कर सकते हैं। तो एज ऑन डेट देयर डिमांड इज 98 lakhs और 43 lakhs. 43 lakhs. तो 98 lakhs वाला डिमांड खत्म हो गया।
To revise the according to him himself.
आप ही बताइए ना, बिल तो आपको लेना है ना?
Yes, it has been revised.
It has been revised and reduced to
43.
43 lakhs, but no separate bill has been issued.
Only an order.
That is only an order.
एक चीज और है इसमें, वो एक्चुअली है 55 lakhs, क्योंकि 12 लाख हम पहले दे दिए तो उसको माइनस करके 43।
अच्छा, उसको एडजस्ट कर,
उसको
वो तब तक डीपीएस में एडजस्ट किए होंगे, इनका तो चलेगा मार्जिन के हिसाब से चलता है। हाँ, वैसे चलता है ना आप लोग का कंपाउंडिंग।
But DPS में DPS है।
कंपाउंडिंग चलता है ना,
Compounding चलता है।
जान बात है।
ये राशि का कंपनी सही लगा।
लिखिए, you see that is a better course. Your entire जो दर्द है ना वो खत्म हो जाएगा। यहाँ पे कुछ नहीं होगा, यहाँ पे फिर इंट्री मॉडल होता रहेगा, यही सब कहानी होती है। Ultimately, that's it. Everything has to be taken to a logical end, right?
I don't understand. ये 43 lakhs जो है ना, that is supplementary bill. In addition to the earlier bill of 21 lakhs.
बिल तो है ही नहीं।
Supplementary sir, order.
You see, I will not say anything. I will say that there is a billing dispute right from 2001, right, which has come up with this now. Now, whatever be the revised order or revised bill or whatever are the pending bills in connection with this, they will challenge it in the for them within 1 month or so.
We shall be
2 महीना दे दे, 2 महीना टाइम दे. Or the learned counsel is appearing on behalf of the parties. WPC number 4838 of 2004 has been filed for the following review. It has been filed challenging the bill dated 1/9/2004, which is said to be a supplementary bill as per the audit objection for a sum of rupees 98,00,086, being the alleged short unit assessment against the earlier bill number 2353 dated 1/10/2001 against alleged pilferage of energy. The learned counsel for the petitioner has submitted that earlier a writ petition was filed numbered as WPC number 4850 of 2001, wherein the bill dated 1/10/2001 was under challenge. The said writ petition was disposed of, enabling the petitioner to raise his grievance before the competent authority. However, at the same time, the petitioner was directed to deposit rupees 12 lakhs in installment to avoid disconnection of electricity. He submits that after the said order, a representation was filed by the petitioner pursuant to order dated 21/1/2003 passed in WPC number 4850 of 2001, and ultimately the impugned bill dated 1/9/2000, impugned supplementary bill dated 1/9/2004 was raised, which was challenged in WPC number 4838 of 2001. He also submits that a counter affidavit was filed placing on record one order dated 31/8/2004 इसमें अमाउंट नहीं लिखा है, ऑर्डर में अमाउंट नहीं लिखा है. This amount is not mentioned in the order and actually हाँ नहीं 31/8/2004
this has been explained by them in their counter affidavit.
Okay.
In counter affidavit, they say that 43 lakhs.
Okay. In which no specific amount has been mentioned, but in the counter affidavit, the respondent has stated that the revised bill amounts to rupees 43,37,961 after adjustment of rupees 12 lakhs already paid. Such statement
The statement
has been made
in paragraph
42.
53 से start होता है उनका 40 page 42 of the counter affidavit, para 53.
It has been made in paragraph 53 of the
और 44 के bottom में
hmm,
conclude किए हैं कि 43
Yes.
37,900.
yes, 53 of the counter affidavit giving the entire calculation. But no bill to that effect has been raised.
तो इसमें हम लोग एक पॉइंट और लिए हैं कि 56(2) में of the electricity act they cannot raise any bill of the period 2 years back, more than 2 years back.
It is based on audit objection. Anyways, the learned counsel has also submitted that the raising of such bills are also barred under section 56(2) of the Electricity Act 2003.
Yes. Yes.
2003, 56 से बोलता है कि they will no disconnection without giving 15 days clear notice. और 2003 आपको लगेगा नहीं, clear है 2003 के पहले.
नहीं ये
56(2) कौन सा नया वाला एक्ट कि पुराना वाला एक्ट 2003 में
नया है।
नया प्रेस है, 2001 का ये है.
बिल का प्रेस के बाद में ना 2004 में
इसमें गाइडेड वाला प्रीवियस है.
उनको बोलने दीजिए
बिल तो रेज किया है 2004
Permission, ठीक.
परमिशन of 2003 Act.
Yes.
The learned counsel submits that consequently the order dated 31/8/2004 has been challenged in another writ petition being WPC number 6848 of 2004. He has also submitted that there is some allegation of backdating with respect to the order and the bill.
because the date has been given as 31st August 2004 और जो पहले वाले केस में जो बिल है वो है 1/9/2004.
The learned
ये
counsel
बिल के बाद
has, the learned counsel submits that the date of the order is 31/8/2004, which as per the counter affidavit results in revision of the bill, but the bill of 98 lakhs is dated 1/9/2004, and apparently there is a mismatch between the bill and the order. The learned counsel, appearing on behalf of the respondent, has submitted that essentially the matter relates to billing dispute and provision of clause 16.9 of tariff is attracted. He has also submitted that the point as to whether the bill was time barred or not is also a matter of fact which requires proper examination. He has also submitted that when these writ petitions were filed, at that point of time, the appropriate forum regarding redressal of grievance in connection with bill or orders of the GM was not available. However, as on date, the petitioner has an appropriate forum, namely
विद्युत उपभोक्ता शिकायत निवारण
Vidyut
उपभोक्ता
Upbhokta
शिकायत
Shikayat Nivaran Forum. He submits that the petitioner may be permitted to raise his grievance regarding the bill and the order which are involved in the present case, and appropriate time frame may be given so that the case be entertained by the forum. The Learned Counsel submits that if such an order is passed, the Electricity Board, the JUBNL will fully cooperate with disposal of the case on merits. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court is of the view that disputed questions of facts are involved in this case, and the point of limitation itself would be a mixed question of fact and law. In such circumstances, the appropriate remedy for the petitioner would be to move the aforesaid forum for redressal of his grievances, not only in connection with the order dated 31/8/2004, but also in connection with other bills related thereto, including
There is no bill at present.
previous bill.
Previous bill तो आप नहीं खत्म कर चुके हैं by this order.
Okay.
बिल अभी order
एक second. Order dated 31/8/2004, and also the calculation which has been projected by the respondents in the counter affidavit, whereby the new amount has been projected, although no bill has been raised so far, as per the records. The petitioner may avail the aforesaid alternative remedy within a period of 2 months from today, and shall also produce the entire records of both the petitions before the forum. If the petitioner moves within 2 months, the forum shall decide the case on merits within 3 months thereafter. The respondent is directed to cooperate for early disposal.
But in the meantime, they may not take any possible step.
Is it a running
Because-
industry?
Because we are paying current
Is it a
bills.
running industry?
Yes, still run.
करंट बिल तो देनी है
करंट बिल हम दे ही रहे हैं, लेकिन इस बिल के बेसिस पे they may not take it.
तो उसमें टाइम फ्रेम हम लोग कितना दिए हैं?
2 months plus
2 months तो हमको दिए हैं।
2 months आपको दिए हैं?
plus उसमें 3 महीना
3.
plus 3
Since the petitioner has enjoyed the interim order of this court, अभी तक चल रहा था ना interim order?
इंट्रीम ऑर्डर ये पहले वाले केस का ही ऑर्डर से होगा।
इस केस में कोई interim order नहीं है?
नहीं, तो पहले वाला जो 4850 जो है उस वही फॉलो किया जाए। हाँ, डिस्पोजल हो गया, but in that case the order was, the observation was कि if I am paying the current bills, there may not take any procedure
that's taken up
on the basis of this case.
The petitioner shall be at liberty to file an appropriate petition seeking interim relief along with the main petition, and the interim relief be also considered by the forum at the earliest. Till the interim relief is considered, there shall be no disconnection, subject to payment of final bills. If not already disconnected. पुराना केस है, we do not. Okay. Yes, Mr. Sinha. These are very old matters.
I'm only on diaphragm not in Thursday but I'm not people. Tomorrow diaphragm not Thursday, your
State कहाँ है इसमें?
private respondent is there, tribal land issue.
Where is the private respondent? आप हैं? SAR case है.
Yes, sir.
What is your main point? छप्पर बंदी.
Prabandhan limitation,
How much is the delay?
more than 40 years. So,
What is the date of disposition?
according to me, the Purnama should executed in the year 1943, and that is the time when they were dispossessed, the ancestors. That's the 14/3/1943. That's the disposition.
Sorry?
Between 73 to 80, private disposal, finding of all goods.
We'll see that. Thursday को? Thursday को? He is seeking time for today. Thursday को?
Several times he is time long. And two courts long after hearing the time long to produce the khadiya showing that it was
कोई बात नहीं, देखिए इतना पुराना केस लगा है. अब वैसे तो अब ये मिस्टर इंद्रजीत सिन्हा आ गए तो कॉस्ट भी नहीं लगा पाएंगे. उनके मैडम को तो हम कॉस्ट लगा ही देंगे. हाँ?
ठीक है जैसा
What advantage is here?
Then advantage given some Thursday.
अभी second half में
With the consent of the learned counsel for the parties, post this case on Thursday
12.
on 12th
12.
at 2:15. First case. नोट बनाइए मैडम.
Ah, yes.
आप भी बना लीजिए ना.
आपको factor चुका है
आप नोट्स बनाए ऐसे?